what you're going to do with it, and how it came into your possession. That you may choose to do that in some form of email in inviting them to be involved with you. I just think it's going to be onerous where, say, people throw a whole lot of business cards into a bowl at a function and then want to use that information to market to those people, then potentially under this they have to explain all the purposes of how, why, and so on and so forth before they can use that information. Maybe it's fair, maybe it's not unreasonable. Your use and or disclosure of personal information has to be managed. So this is something as a small business we all need to be aware of. And I don't know about you, but I do have an inbox full of emails, and I have not previously gone through and categorized a lot of those emails to say, yes, I should delete this, I shouldn't retain this information, I should store this information in a particular place, all those sorts of things. Right now I'm not actually using it, I'm just holding that information. What I should be doing is making a decision as to whether or not I'm going to use that information, and if I'm not going to use it, I should be deleting it. The issue of disclosure is, what do you do with personal information? So if you're collecting it through your website and you're building a list of people, don't share the list unless you have permission from the list to share it. Now that doesn't mean you can't promote someone else through your list. So an associate of yours who has a complementary product may come to you and say, hey, look, you've got people who may be interested in what I do. How about we put something together and we market it? Now, a great example of that is the Harry Dent seminar series that's going on around the country at the moment. Harry Dent is an economist from the US, and he has connections in the seminar network in Australia. He's currently on an Australian-wide tour, and all and sundry are promoting him. Now, I'm on a number of different people's lists, and I think I received 4 different promotional emails for his presentations, because clearly he's got involved with a whole bunch of people. And they've not given him their list, but agreed to promote what he's doing to their list. All right, direct marketing. Now, you can build a list for the purpose of direct marketing. What the Australian privacy principles say now is, if you're going to do that, tell people. So your privacy policy should say, hey, if you give me your name and email address through the web form on the website, I'm going to add you to a newsletter list, or I'm going to send you to a marketing list, or I am actually going to market directly to you. Now, a lot of people understand that when they put their name and email in a web form. Just in case somebody doesn't, that's where you need to put it in your privacy policy. Cross-border disclosure of personal information is the new flavour of the month, and the reason this came about is because the big banks and telcos have outsourced a lot of their customer service overseas, and a lot of people have got upset because when they first started doing this, what was happening is all of these contact details and customer details were being outsourced overseas, and then the information was being on-sold to other entities overseas. And people were getting all sorts of calls and emails and letters and marketing from people they'd never heard of before, just because they happened to be, you know, a telco customer or something like that. So that's why it's become really important. It's because a whole lot of people were upset because their personal information went overseas without their knowledge, and then it was misused. So it's unlikely nowadays to be misused, but it's our obligation as an Australian business entity, if we're going to use overseas service providers, customer service, whatever we use them for, we are obligated to make sure they comply with our privacy obligations. We can't just throw up our hands and say, oh, well, they're overseas, it doesn't apply. We actually have to monitor what they do and control it. Now, I did say I would leave questions to the end, and I'm getting quite a few of them now, so I'm sorry. I do understand that they are relevant on the way through. I just can't do both things at once. So what I'll do is I'll come back to the questions for a second. I'll read out a couple of questions for you. Could a wholesale organisation request a login and approval before providing catalogue information, such as a fashion wholesaler? They do. To be honest, they do. That's part of the problem. And at the moment they can, but it'll be interesting to see over the next couple of months, as soon as these Privacy Act changes come in on the 12th of March, what the Privacy Commissioner does about it. Because they're supposed to make that information available to people who choose to remain anonymous, as opposed to requiring people to give information. So they can, what they should be doing in terms of requiring a login is actually making it a choice, particularly if that's the only stuff they're putting out there on the internet. What's the consequence of using email? This is another question. What is the consequence of using email information other than for the purpose they thought? For example, signing up for a free report and then being added to a general newsletter list. Well, in Australia, we're really lucky because our privacy law does say that even if you give your personal information to somebody for a specified purpose, so for the purpose of receiving a product, that company or that person can add you to a list and market to you if it would be reasonably expected by you. So if you go on to a website and you download a book, you give your personal details to download a book about property investment, then it would be reasonable that you receive some marketing around that complements property investment. Now that may be around finance, that may be around home decorating, that sort of thing. But you wouldn't expect to receive marketing for, say, a trading platform, a share trading platform, because it's not, yes, it's maybe investment, but it's a different category of investment to property investment. So you've got to be careful what you're marketing to your list and how it's complementary to what you do and what they signed up for in the first place. Another question, what if I sold my business as a total entity? Can I pass my list of subscribers or customers to the new owner? Yes, you can. If it's a business, your list is a business asset, and you can, but what you should be doing is letting your list know that the business has been sold and the new owner has taken it on. And you can make provision for this in your privacy policy. So you can say in your privacy policy that personal information will be transferred to the new owners if the business is ever sold. Simple as that. Okay, somebody's asked me, is Harry Dent doing anything wrong, or are the promoters of Harry Dent infringing new privacy laws? Well, the laws aren't in effect just yet. The people who have sent me his information, it's not unexpected. As far as I'm concerned, I'm not surprised that they sent me that information, because consistently they've done that over the last year or 2 years or however long I've been on their lists. So it's not something unexpected. It's not a big surprise to me, and I can, it doesn't bother me that that's come in under my email address. However, if, for example, I was in health and wellness and the health and wellness subscription service that I signed up for is all about motivational quotes, I get a daily motivational quote, and then all of a sudden they give me a promotion of Harry Dent, I might be put out. And that's where there's an issue, whether it's reasonably contemplated by your list that you would get this kind of information. How is it going to be policed? Somebody's just come up with that question. Well, this is another one of those government entities which works on the complaint system. So the more complaints they get, the more investigations they'll do. They have, from what I understand, and this is just gossip around the traps, but from what I understand, they already have a few business sectors targeted that they want to investigate as soon as these laws come into play, and sort of test how robust the laws are in terms of what the decision makers are going to say about it, and how many fines they're going to be able to collect. So it's going to be interesting to watch what the Privacy Commissioner does over the next 6 to 12 months, but I would not be surprised if there is a few companies that collect some pretty hefty fines for the way they manage their personal information. Now, as a small business, what does this mean for you in terms of risk? Well, it means you probably have a low risk as long as you keep your customers happy. Now, I was talking to somebody recently and we discussed the fact that in any business, no client base is going to be 100% happy all of the time. You're going to have 1 to 3% of your client base unhappy for any particular reason. It may have nothing to do with you. You may just trigger what they're upset about today. You don't want your clients or customers or people on your list complaining to the authorities, because when you come to the attention of the authorities, they don't ever let you go. You become sort of part of their hit list. So they never hear about you before, and all of a sudden they get one complaint. And if it's a really serious complaint, then you're almost on a watch list. And I'm not involved in the inner workings of the Privacy Commissioner's office, but I have worked with Consumer Affairs before on behalf of clients, and seriously, I've had clients that really struggle to do business after they've come to the attention of Consumer Affairs because they've ticked off 1 or 2 customers, and then Consumer Affairs come after them every 6 months or so to check that they're compliant with what they're doing. So in terms of it being policed, it may not be a big deal to start with. They may go to the bigger companies, but it could become a bigger deal down the track. And if any one of your customers complains about you, it's not a position you want to be in. Okay, I'm going to move on with the slides again, and then we'll come back to some more questions in a minute. Now, the last of the privacy principles are the adoption, use or disclosure of government-related identifiers. Now, this has more to do with particularly health service providers. So with the new e-health system, if you're a health service provider, you may or may not have a permission to use, say, a Medicare identifier to identify your clients. If you're in a different industry, say your small business, whatever your small business is offering, if you asked people and said to them, hey, I want your tax file number, and then you identified all your clients by their tax file number, so in your lists and everything, so that their personal information wasn't the primary identifier, then you're in breach of the privacy principles, because there's a specific prohibition against using those sorts of government identifiers to identify your client base or relate to your client base. And that's part of the reason if you're employing people and you collect their tax file number, you do it on a form that needs to be kept securely, and you shouldn't make their information publicly available on any sort of payroll system for the rest of the business. Okay, the quality of personal information, what we're talking about there is whether you've got it right or not. Now, if you remember back in the beginning, personal information can include an opinion and it need not be true. So the quality of personal information is a little bit of a contradiction, but essentially what it's coming back to is making sure if you retain personal information for a specific purpose, and particularly if you're going to make it available in a public publication, so a directory, that you keep it as current as possible. And people if you have a look at 12 and 13, which is access to personal information and correction of personal information, your clients, customers, whoever it is on your list, have the right to come to you and say, hey, that's wrong, or what information do you have about me, and can you tell me what it is so that I can correct it? Okay, I've just had a flag. Somebody said they've lost audio. Can anybody just send me a message and let me know if they're having troubles with audio as well? Audio good. Okay. Alrighty. So most people can hear me. So if you're having trouble with audio, it might be your end. Okay, great. All right, moving on. Access and correction of information is about allowing people to come to you and say, hey, what have you got? Let me know what it is, and I will tell you whether or not it's right. Now, if somebody wants to correct their personal information, particularly if there's opinion in there, they can give you the information, but it does not mean that you have to replace what you've got with what they give you. So if what they give you is contradictory to what you say it should be, and this came about mainly with medical information, particularly where doctors were putting opinions and comments about their clients into medical files, and then clients were accessing those files and saying, hey, I'm really not happy about this. So if a doctor's written in a medical file, this client's a hypochondriac, blah, 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 the client comes back and says, what personal information have you got about me? Show me that. Hey, I'm not a hypochondriac. I expect you to delete that. Then the doctor actually has the right to say, well, I disagree with you. I will record what you're telling me and I will put it with the personal information I've got, but I'm not going to change what I've got. So that's the ability that you have in terms of maintaining personal information. Now the last one is, or I've skipped over it, but coming back to number 11, the security of personal information. What that is you actually need to understand the security around your systems. So we were talking about inboxes before. If you've got a full inbox, does your computer have some sort of password access or finger scan access or something so that everybody in the household can't just get in there and read through it? So that's really coming back to basics of the security around personal information. It's making sure that it's not readily available to anyone but you unless they're an authorized person in your business. So it doesn't mean that you have to restrict the flow of information within a business. It just means you need to be really aware of how it happens and who has responsibilities around it. Okay, basic compliance. Just to get yourself over the line and make sure that you've got basic compliance, you can at least respond and say, yes, I understand I have obligations and this is what I've done which I feel is reasonably practical in my circumstances. Have a privacy policy. Now, I asked a room full of people on the weekend how many of them had read their privacy policy, and it was about 5%. So if you've got a privacy policy and you haven't read it, please go and read your privacy policy and at least have some idea of what's in it. Now you need a procedure to back up your policy, because having a policy is great. It says we're going to do this, but then how do you implement it? That's what the procedure is about. It's having the background step by step so that when you get a question about compliance, when you get a complaint about how personal information is being handled, you actually know what to do with it. And having that procedure, you then need a little bit of staff training. And staff training is about raising awareness with your staff around what exactly is personal information. So there's a whole bunch of stuff that isn't personal information. And there is a whole bunch of stuff that's not necessarily covered by the Privacy Act. So you might have information that somebody says is confidential, which is not personal information, which is therefore not covered by the Privacy Act, which is therefore not covered by your privacy policy, and so you will have a different response to that person than if they did have personal information that you had to disclose. You need to understand what you do with records and document management in your business. Now, I know that this is huge for most people because I know lots of people who can't even organise their folders on their computer or their filing cabinets, and they need someone to help them around that. I've looked at records and document management systems online. I've done Google searches. I've looked at what universities are doing. I had a look at a report where Rio Tinto spent 4 years updating all their documentation management. It doesn't have to be that hard. You can practically deal with it. All you got to do is look at what do I have and how do I deal with it? Destruction of information. What the Privacy Act says is that if you collect